Hey everyone, Rob Ryder. Today, this may be kind of long. You may want to stop right now and go get yourself a beverage or whatever you need, piece of paper, pencil. Going to want to write a few things down. Um, that's my opinion, but we'll find out. But I'm just warning you ahead of time. It's going to be kind of long and it covers a lot of different topics because there's lots going on. And these aren't to give any particular remedy. These are to show things that maybe we should look at closer to see if there is a remedy. So today is the ABCs of false personation and without license. And only a peace officer can arrest you. And only a licensed attorney can practice law in a state court. The question is, can they prove their claim? We're going to look at some things to say, well, show me this or that or whatever, or you're not who you say you are and I'm going to do this. And we'll get into what the this is here in a bit. But for instance, by the way, today is Saturday, October 25th, 2014. A peace officer or law enforcement officer in North America is a public sector employee. They work for the government, therefore they're not a private contractor. As Rod Class had pointed out to him by the courts of North Carolina, all the cops are private contractors. Therefore, they're not a peace officer. Let's continue on. Whose duties primarily involve the enforcement of laws. The phrase can include police officers, corrections officers, customs officers, state troopers, blah, 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 and arson investigators of all things, which is kind of interesting. I came across this thing in the Illinois compiled statutes about the state fire marshal appointing arson investigators as peace officers, and then they get a special badge. Auxiliary officers, sheriffs, marshals, and their deputies. Now the thing with a lot of this is we don't know who these people are. Lowercase sheriff doesn't have to be the sheriff of the county, right? That we think of as a county because that's a corporation anyways. Marshal could be a fire marshal, right? That's a marshal. The sheriff in Old English law, he was just the king's top businessman within a jurisdiction. And I think that today we could say that, like in a city, that the sheriff is the city manager. And you'll see in a bit, he's tasked with, guess what? Enforcing ordinances and the law. Well, that makes him law enforcement. Security guards are not normally law enforcement officers unless they have been granted powers to enforce particular laws, such as those accredited under a community safety accreditation scheme. And I just love the word scheme. So these people that we're dealing with are mainly security guards. Now, right, can they enforce the law? That's yet to be determined, but they're not a peace officer. Modern legal codes use the term peace officer, in some jurisdictions law enforcement officer, to include every person vested by the legislating state with law enforcement authority, traditionally anyone sworn, badged, and armable, who can arrest or refer such arrest for criminal prosecution. Sworn, badged, armable. Legislative state law enforcement authority, with law enforcement authority, right? So whoever the state says is law enforcement is law enforcement. And if they don't say the security guards are, then they're not, right? But basically they have to be public sector employees. They have to work for the government. They can't be a private contractor. Hence, city police officers, county sheriffs, deputies, state troopers are usually vested with the same authority in a given jurisdiction. Contract security officers may enforce certain laws and administrative regulations, which may include detaining or apprehension authority, but not arresting. Now we get into the thing, well, when does it quit being detainment and become an arrest? I say as soon as you hold me against my will, I've been arrested, unless you have a complaint, right? Now the thing about administrative regulations, well, those would be ordinances. That's what a city can do. They have administrative powers, not necessarily judicial. I'm not going to say that. I'm just going to say the difference is administrative are ordinances and laws are, judicial. Peace officers may also be able to perform all duties that a law enforcement officer is tasked with, but may or may not be armed with a weapon. Okay, so that's really it about peace officers. And I threw this in about administrative law judges because this is going to become, we talked about this in my last video, and it's going to become more important that an administrative law judge, first of all, in the United States is a judge and the trier of the fact. And that's really important because we need to have facts tried. We're not trying to try the law. We want to try the fact. And the fact is, this guy doesn't have the piece of paper to do what he says he can do and is doing right now. He doesn't have a license, basically. Right? Administrative law judge, try the facts, make a determination. So, who both presides over trials and adjudicates the claims or disputes, in other words, ALJ controlled proceedings, are bench trials involving administrative law. And we're trying to get things administered, not judges can really, they get involved in controversies between people and also to interpret the law. And we're not trying to have the law interpreted, we're trying to have it enforced. So you go to an administrative law judge to have a law enforced, right? Because he can take it and well, let's see, he can do a bench trial. The ALJs can administer oaths, take testimony, rule on questions of evidence, make factual and legal determinations, and depending upon the agency's jurisdiction, proceedings may have complex multi-part adjudication, as in the case of federal energy regulations. All right, so all these different organizations can have their own administrative law judge, but the Bureau of Labor and Statistics says an administrative law judge, adjudicators, and hearing officers are, they're all the same. And in a lot of cities, you find that somebody has been appointed to be an administrative hearing officer, which is the same as saying an administrative law judge. And the hearing officer is there to hear controversies having to do with the ordinances. And it probably isn't a judge; it's just somebody. It's an attorney they hired. If you have a municipal court with a judge, he's going to be important later, but he's not the one. That's the one you're probably going to go see. If you had a traffic ticket, the guy you're going to go see because of the ticket isn't the guy I'm talking about. It's the guy you didn't go to first. Because normally in an ordinance, you're supposed to go within 10 days, take care of it. And if you don't follow whatever the rules are of that city, because it's a must appear, you've been subpoenaed, basically, and you don't appear, well, now it's contempt of court because you failed to appear, and now they're going to send it over to the other judge. And all this is going to happen before you ever stepped into court the first time. You're already going to be in contempt of court for not showing up for the ordinance violation. That's why they schedule the damn, traffic ticket 3 weeks out. You're not going to be there unless you're in contempt of court for not having gone somewhere else first to take care of the matter. Excludes arbitrators, mediators, and conciliators. Okay, so they're not who we're talking about. But they conduct hearings to recommend, make decision on claims concerning government programs, other government-related matters, like ordinances, determine liability, sanctions, penalties. Yeah, it's a judge. Okay, now, bench warrant. Just some terms to know because they're good to know. Because when you get arrested, right, with an arrest warrant, that's not a bench warrant. A bench warrant is a variation of an arrest warrant that authorizes the immediate on-site arrest of an individual subject to a bench warrant. Typically, judges issue bench warrants for persons deemed to be in contempt of court, possibly as a result of a person's failure to appear at the appointed time and date for a mandated court appearance. That would be a bench warrant. Well, in rem hearings, which are asset forfeiture actions under maritime law, they issue an arrest warrant. If the plaintiff's attorney certifies the exigent circumstances to make the court impracticable, the clerk must promptly issue a summons and a warrant for the arrest of the vessel or other property that is subject to the action. That's the kind of arrest warrant they're using against us. We are in rem proceedings, right? They're using maritime law in a state court that allows them to do it under a civil action because they wanted to come up with one type of action, and it's called a civil action. And in that civil action, it could be something in law, in equity, or admiralty jurisdiction. 3 different jurisdictions. They're bringing it into admiralty jurisdiction with an in rem hearing, which means it's about the ownership of property. It's not against you yet because of the way they're doing it incorrectly. Because the only in rem hearing they're supposed to bring to a state court is a money judgment. And a money judgment would be somebody saying, you, whoever you are, owe me money. But they're not doing it that way, right? They're like in a foreclosure. I'll show you a foreclosure. It's an in rem judgment. That means it was about property. It wasn't personal, right? It wasn't in personam. It was never against you. It was about ownership of property. Well, they can't do that, right? Because they're acting like it's a maritime lien, and the frickin' contract never happened on the water. There was no contract. They didn't sign the contract. Blah, 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 blah. Okay. Anyways, I am Rob Ryder, Court of Record. AOL.com is my email address. Always the easiest way to get a hold of me. Or phone. If you can, please do donate. It's the end of the month and I can't pay rent again. I apologize, but hey, this doesn't pay very well. I got almost 200 videos. I'm glad I ain't getting paid by the word. I wish I did get paid by the word. Ashley Rytlewski, ASHLEYRYTLEWSKI @gmail.com. Why don't you stop right now and write that down? Pause your damn computer. Or the snail mail to myself. Cash, money order, check. Alright, sure use it. Working real hard, guys. Hard as I can. Apparently I don't have anything to offer. So, enough on that. But this in rem action that's happened in state court, and that isn't really what this particular video is about. But we are going to show a few things so you get your head wrapped around it. Figure out what kind of questions to ask. But the main things are going to be saying, hey, the guy that's representing the plaintiff, I don't believe he's licensed to practice law in the state. Well, that's how we're going to handle that one. So before we get there, though, because like I said, there's so many things to talk about, this is mainly what the video is. This is just something I came across that because I did. I have one of these forms here. Maybe you do too, right? This is a little pamphlet that your Social Security card came on, I guess, when I was a kid, because I haven't. I've had it like forever, but I never knew what it was. That's what it looks like. And attached to the front is this part right here that has a Social Security number at the top, and then it has a name here, right? So forth and so on. Well, that's called the stub, right? And the top half we're going to call the Social Security card, just to keep them clear. And most people have the Social Security card. That's the one that's got the number on the back. To me, that's a file number for a file within a court, because not all courts have to be courts like you walk into. Court of record is just where the records are. Whatever the record says, it's what the court agrees with. So where's the court? It's where the records are. That's what this is. There's a record someplace, and I believe that is a file number to a particular record that shows who's the owner of the property on the front. And when they open it up, right, that when you read, so if you read the back of the stub now, thinking about that, detach this portion. I'm reading mine. I don't have hers, so I can't show you. Detach this portion from the upper half of the card and keep it in a safe place. Your name and Social Security account appear on the other side. Stop right there. Your name and Social Security account number appear on the other side. Well, when I flip mine over, instead of having Robert Allen Rytlewski like it does on the upper half with the Social Security number, it has Robert A. Rytlewski as the owner. Well, that dude doesn't exist. And if you look at this lady's name here, Adeline, there's a space between Adeline. Done on purpose. Adeline Ann is not the same as Adeline Ann who signed the bottom. She don't put a space between her name. Roe looked at hers, and on her stub they put her all caps name. Well, that isn't her either. That's not your, your name in person, your in person, what do I want to say? Um, proper noun name, proper person name, I guess we would say, is your full name, written proper case, start it with a capital and the rest is all lowercase, like this. I mean, this is proper case, Adeline Ann, but they put a space in her name. On Rose, it isn't in proper case, it's in uppercase. So the name that's tied to the account isn't your name the way you believe it to be. It's my opinion. So I just sent, because I could, and this is the great thing about this stuff, right? Inspector General, Social Security, and I sent him a complaint complaining that Social Security was involved in waste, fraud, and abuse because they had intentionally, or somebody had intentionally, put the wrong name on my account and it wasn't tied to me. Right, that on my baptismal certificate, it has Robert Allen Rytlewski, and that's the name I go by, and Robert A. Rytlewski is not my name, and I want to have the record changed, and I want to have my proper name and my property tied together, and I claim full rights, title, and interest, and while we're at it, give me an audit. I just did that on late Thursday, and I got a letter that, said they got it, so I did it all by email. Now, Roe went down and tried to do this at the Social Security Department, and with by doing the SS5 and claiming that the name was wrong, because it's all caps, and the counter troll's kind of lost, and she goes and gets her boss, who's soon as lost. But that what they're going to have to do is send Roe something in writing. And she said, what, about going to the administrative law judge? Because one place at all there are administrative law judges attached federally to the Social Security office. But a administrative law judge in the federal level isn't confined to a particular thing. He's got general jurisdiction, basically. And it looks like they're in the federal building. At least mine's in the federal building. It looks like he's attached to the Social Security office, but he's not in that building. He's in a federal building. Just something to think about. If you have the stub, go look at your stub and see how they did your name and see if it is the same as you know your name to be, because that is the owner of the Social Security account. And again, on the back, I think that number there is a file number that's going to go to a file. Now, it could be that it's at the at whatever, because the first letter, a lot of people believe that to be the Federal Reserve branch that it's in. It could be, right? But the rest of it's a file number. It's the file number in that bank that says when you go there and you look at it, you're going to find out who the owner of the account is. It's not under your name. It's under a file number. And so the original certificate of title is sitting in a drawer under that file number, and you have the owner's certificate of title with that little thing on there because you got it on the back. So we need to show it to them. So I'd like to see the original certificate of title. You see if that changes it. That's your title paperwork to that account. So, okay, well, that's enough of that. Shut this down. Where are we going next? Man, I got so much to talk about. All right, well, let's go here. How about we look at peace officers first? Wait, stop. I don't want to do that yet. Where is that thing? Bob, where did I put yours at? Okay. This is a foreclosure judgment from last year for Bob in Pennsylvania. Bob Carr. How you doing, Bob? I know you'll be listening. Check this out. This was the verdict. Now, Bob's still in the house. This is 2 years ago, right? That they gave a verdict and judgment that in the favor of the plaintiff, but he's still in his house. Ordered and decree that a verdict will be and hereby is entered into a favor plaintiff, city mortgage, blah, 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 in the amount of, right? So this was for money damages, right? In the amount of this much for money damages. It is further ordered and decreed that an in rem judgment is hereby entered in accordance with the foregoing verdict. So the verdict was, well, a verdict would come from, don't verdicts come from juries? Or maybe it's either a jury or it's a chancery court. But either way, but an in rem judgment was entered. Well, in rem judgments are only to determine whose property it is or what your status is. Right? This in rem judgment is for money damages, is what the state court could be used for in admiralty law to get a judgment on money damages. And so they're using admiralty law in a state court. And what it says when you go read the rules about admiralty law in a state court is it says the state, even if it violates state law, you follow the admiralty court law. And that's the jurisdiction that this has been brought into on a civil action, because civil actions are used for all three types of jurisdictions: law, equity, and admiralty. And so, you need to, if nothing else, I'd challenge jurisdiction. Say, you can't bring this in admiralty jurisdiction. This contract didn't happen on the water, and I'm standing right here, right? If this is a money judgment that you're after, then it has to be in personam, and I'm not the defendant, right? They have your all capital letter name, or they got some crazy ass stuff, but it's never you, right? It's a fiction. Go look at the docket sheet. You got your name backwards. Right? It isn't you that came to court. So that's just to show that, hey, we are using admiralty in state court. More on that here in a bit, but that really wasn't the main gist in this, what we're going to be in. Okay, peace officer. False personation. Well, let's look at peace officer first. This is from Illinois. Peace officer: any person who by virtue of his office or public employment is vested by law with the duties to maintain public order or to make arrest for offenses. Right? Got to be a peace officer to make an arrest for an offense. For the purpose of assisting Illinois peace officers in an arrest, employees of the federal government commissioned by federal statute to make arrests for violations of federal criminal laws shall be considered peace officers under this code. All these guys are peace officers. Could be peace officers. If they're helping a peace officer in an arrest. Means a peace officer who is employed by a unit of local government or state college or university, including supervisor and command personnel, and any pay grade investigator for the Secretary of State as defined in section something or other of the Illinois Pension Code, including Secretary of State sergeants, lieutenants, commanders, investigator trainees. Okay, so then this goes into the term does not include who it does not include: state's attorney's office, traffic wardens, parking enforcement personnel. Right? Well, what's a parking enforcement personnel? It's like the dog catcher, right? That's the I shouldn't say that. It ain't like the dog catcher, but it's somebody who's doing ordinance violations, right? They're a paid informant for the city, going around saying, "Hey, you're parked in the wrong spot," writing up a ticket. Taking it up to the administrative hearing judge for a hearing that you're not going to show up to because somebody's not going to mail you the paperwork that was supposed to be mailed to you, and they're going to say you didn't show up, and then it's going to go over to the other court, and bada boom, bada bing. I don't know they're doing that with parking tickets. I haven't gotten one, right? But that's what's going on with traffic tickets. Anyways, there can be these administrative proceedings to have to do with, Like interrogation means the questioning of an officer pursuant to formal investigation procedures, respective state agency or local government unit in connection with alleged violations of such agencies or units' rules, which must be based on filing charges seeking his or her suspension, removal, or discharge. Well, that's exactly what we're going to do, because we don't believe the guy that came and gave me a ticket or put handcuffs on or whatever it is, that they're actually a peace officer. They're going to be an administrative proceeding. And, who would you do this stuff with? Well, normally it would be internal affairs. If it's too small of a town to have an internal affairs, I believe it's going to be the city manager, because he's tasked with enforcing the ordinances and the laws. And if he's enforcing the law, he's law enforcement. The interrogation shall take place at the facility. So either it's false personation or it's official misconduct, right? Those are the two directions that this can go. Anyways, that's just what this is about, that to show you that they do define who a peace officer is. In Illinois, I don't know if they do in your state, go look it up, see if they do. False personation. This is all about solicitation, this first part, which is really interesting, because this is another thing we're going to have to do, I believe, that should be done, is you have all these businesses in the town, and none of them have a business license with the city. And so they're soliciting without a license. And that could be a church, fraternal order of whatever. It could be the bank. A bank is a nonprofit. They're soliciting. I mean, all these things. The banks aren't, but credit unions are. Right? But nevertheless, every business is supposed to be licensed with the city, and they're not. Well, then that's an ordinance violation. Now, they're not doing it because of what it would cost to get a license. That's, $5-10. It ain't very much money. There must be a reason they haven't done it. So let's force the issue and say, well, I'm going to put in for an ordinance violation because this company doesn't have a license with the city. And this goes back to the fact that Roe had found, God, I can't remember the name of the book she got at the library, but it was a list of all the businesses, or a good list of businesses, and it listed these two companies in Batavia, Illinois, which is not too far from St. Charles or Geneva, where all this action happens at. But that's where their working address is in Geneva, in the courthouse. And they're two private for-business companies, one called Civil Infraction. I can't remember the names, but it's just like if you were walking up and looking at the sign for the traffic court and the civil, whatever those words are, those are the names of these companies. They have offices in Batavia, but they're not registered with the city. I think we should go register them with the city and see what happens to them. Those persons should use the words police, police department, patrolman, sergeant, lieutenant, peace officer, sheriff, right? You can't use them words unless you are one. Right, unless it's been without express written authorization of the state, agency, public, university, or unit of local government. All right, so they walk up and say that they're, a police officer, they're sheriff's police. Look at that, sheriff. What is sheriff's police? Sheriff, officer, any of these words. Deputy sheriff, says it on the car. Right, when they pull up and it says deputy sheriff in the car, they better have written authorized personnel, written authorization to do that. So this is all about soliciting. That really isn't what I want to talk about. I want to talk about this: false personation, public officials and employees. This is huge. An attorney authorized to practice law for the purposes of compensation or consideration. That is false personation of a public official. And the reason for that is attorneys are considered officers of the court. In fact, John in New Hampshire just told me this week, because he tried to put the attorney in a foreclosure under oath. And the judge said, well, I'm not going to do that. I said, he's considered an officer of the court, and therefore he's already under oath. We assume he's under oath. We presume him to be, let me back up, we presume him to be an officer of the court, and therefore he's already under oath. And it's that presumption, right? Nobody has challenged the fact, well, let me see his license to practice law within the state, because if he doesn't have a license to practice law within the state, it's the unlawful practice of law within the state. That's contempt of court. And that's what we need to handle it for. So if he's working for $1, purposes of compensation or consideration, I guess they can have fees, and they must be different than compensation or consideration. I'm not going to get too deep into that, other than, it got me to look at attorneys closer, and by God, these guys they don't have a license. And the easiest thing to tell you is most of them, I don't believe, have ever signed their oath. They never subscribed it. They went to a mass hearing, they all raised their hand, and they swore it just like being in the military, but they didn't go sign it and have it notarized. There's no memorial to the event. I don't know that they were ever there. And neither do you. That's one kind of false personation. Public officer, public employee of the federal government. Public officer, public employee of the federal government. Public officer or public employee, a false representation of the purpose of effectuating identity theft as identified and whatever. Well, none of these public officers are elected. They didn't sign an oath. They don't have a bond. They didn't follow election laws to get to where they are. None of this has happened. It's all of them are impersonating an officer. But here's ours. Peace officer. Peace officer while carrying a deadly weapon. Peace officer while attempting to commit a felony. Peace officer in attempting or committing a forcible felony. And what's force? For them to touch you. It just became a felony. Put handcuffs on you. That's forcible felony. Right? They don't have this is what they're guilty of. False personation of public officials and employees. And this is from the dude in the cop car to the guy sitting in the mayor's chair, to the guy sitting in the county commissioner's chair, to the judge sitting in the judge's chair, because a judge is supposed to be an attorney licensed to do law in the state, and they ain't got the damn paperwork. It's my opinion. We're going to for these reasons, because of my opinion, we're going to go find out. Yeah, but more people trying is good. Now, here's the thing, though. Now we come back to administrative law judge. He's the trier of the fact, right? So the trier of the fact, the administrative law judge, may infer that a person falsely represents himself or herself to be a public officer, a public employee, or an official of the government, of the federal government, if the person wears or displays without authority any uniform, badge, insignia, face, meal, therefore or thereof, by which the public officer, a public employee, or official or employee of the federal government is lawfully distinguished. You can't dress like a cop unless you are a cop. Falsely expressed by word or action that he or she is a public officer or public employee or official or employee of the federal government with approval and authority of the public agency and department. There's a really good question to ask when they pull you over. Are you a public officer or public employee? Yes or no? Start there. Fraudulent advertise of a corporate name. Right? This is a false personation of public official or employee. It's in the act. Don't ask me. Fraudulent advertise a corporate name. A company, association, or individual commits fraudulent advertisement of a corporate name if he, she, or it, not being incorporated, puts forth a sign or advertisement and assumes, for the purpose of soliciting business, a corporate name. Excellent. They're not, you can't. So we've been trying to find the bylaws and articles of incorporation and these other pieces of paper that every company who has an EIN number is supposed to have provided in becoming a business, especially if it's a nonprofit business, right? Or if you want to get a business license within the state and you want to get a tax exempt number, you have to produce this. Well, none of they don't have any of this paperwork. You get a hold of these on. We ain't got it. Don't know what you're talking about. You call the entity. No. Call your county and tell them you want to see their bylaws. They're going to say they don't have any. Well, the county's incorporated. Well, they can't be incorporated. They don't have any bylaws. I guess it's fraudulent advertisement of a corporate name. And who do you take this stuff to? Right? Well, it goes to an administrative law judge, the dude that's going to try the fact. False law enforcement badges. A person commits false, just to point out, okay, if you're wearing a badge, it could be a false one. Now, the differences in attorney. Attorney at law, a person admitted to practice law in his respective state and authorized to perform both civil and criminal legal functions for clients, the key word being authorized, including drafting legal documents, giving legal advice, so forth and so on. You need to be authorized. Who authorizes you? The Supreme Court does. In English law, a public officer belonging to the Superior Courts of Common Law at Westminster who conducted legal proceedings on behalf of others called his clients by whom he was retained. He answered to the solicitor in the courts of Chancery and the proctor of Admiralty, ecclesiastic, probate, divorce courts. Right, so different names. You called him a solicitor in the court of Chancery, a proctor in Admiralty, ecclesiastic, probate, and divorce courts. An attorney, but they never call these guys that. They call him counselor or the attorney, right? So, according to this, he's not an attorney at law. An attorney who almost invariably also a solicitor, it was provided by the Judicature Act that solicitors, attorneys, or proctors or by law empowered to practice in any court jurisdiction, the jurisdiction of which is by the Act transferred to the High Court Justice Court of Appeal, shall be called solicitors of the Supreme Court. Right? They're not called a solicitor of the Supreme Court. In England, they are not an attorney at law, and they're practicing law without a license. All right? Solicitors of the Supreme Court. Sorry for you folks in the UK, I should have pointed that out. Excellent. But, well, what do we have then? Well, we're dealing with people that are called attorneys in fact. A private attorney authorized by another, but not by the government, not by the Supreme Court, to act in his place instead, either for some particular purpose or as to do a particular act, or for the transaction of business in general, comma, not of a legal character. This authority is conferred by an instrument in writing called a letter of attorney, or more commonly, a power of attorney. They're nothing more than an attorney in fact, and they can't practice law because they ain't got a license. And they're impersonating a public officer because an attorney at law is a public officer. It's considered an officer of the court, always in court. Attorney on record, attorney, okay. Anyways, right? To me, they should be called lawyers. A person learning the law. As an attorney, counsel, or solicitor, a person licensed to practice law, right? So if they're a lawyer, well, then they're licensed to practice law. Now, there's one other thing. I believe there's various jurisdictions within. That's why there's different bars. You got the state bar. State bar allows you to practice in state courts. Well, then why is there a county bar? Why does every county have a bar if there's a state bar? Well, that bar must be to allow you to practice in the county court. And it's then in the county court where all this action is happening. And in the county court in Old England, it was only for suits of less than 40 shillings. So it was never for money. It was for property damage. It had nothing to do with money. It was for suits for less than 40 shillings. So it was about who owned property. Right? The court of proof, the court of probate, the court of record, the county court. And so these guys are probably in the county bar, which means, yeah, we could practice law in the county courts, but they really can't practice law in the state courts, yet that's where they end up taking you to, is the state court. They open it in the county court, and then they transfer it to the state court, to a different jurisdiction. And in that court, you need to be a licensed attorney. And I believe we're going to find out they're not. And the easiest way to find out is the clerk of the Superior Court, or the Supreme Court, has the roll. They know who is. Continuing on. We did that one, that one. Peace officer status. Any person who is sworn member of any organized or paid fire department or political subdivision of this state and is authorized to investigate fires or explosions may be classified as a peace officer by the political subdivision or agency employing such person. Right? So your fire marshal, not just whoever is authorized to investigate. Just ask me, are you a peace officer, by statute? By law, whatever it would be, and you could take him your complaint. It's somebody you should be able to take your complaint to, right? And if there's probable cause, he should take it to the trier of the fact. A person so classified shall possess the same powers of arrest, search, seizure, securing, and service of warrants as sheriffs of counties, police officers within the jurisdiction of the political subdivision. Because again, I don't believe the people that we think are. In fact, Ron Class proved it. They're not frickin' police. They're private contractors. Well, then who is the police? Apparently one of them could be an arson investigator. State Fire Marshal, Investigator, Special Agent is another one. It does not include any fire investigator, fireman, police officer, blah, 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 other than employed by the Office of State Fire Marshal assigned to investigate arson. So we're not talking locals, right? We're talking state fire marshal, arson investigator, special agent. He is a peace officer. The state fire marshal must authorize each employee of the Office of State Fire Marshal who is exercising the powers of peace officer a distinct badge that on its face clearly states the badge is authorized by the Office of the State Fire Marshal and contains a unique identifying number. I'll get too much more into that. Just to show you. Go find a fire marshal. Take him your complaint. Okay, and then here we go. This is for Coldwater. This is for Jerry. Hey, Jerry, if you're watching. Coldwater City Charter. The manager is responsible to the council, ensures that laws and ordinances are enforced. Well, that makes him law enforcement. And the city manager, he's appointed, right? He wasn't elected. He comes in from the outside. He's like sent from the king's officers. Right? He's not a local yokel. However, continuing on, authorized city official means a police officer or other personnel of the city authorized by these codified ordinances or any ordinance to issue municipal civil citations or municipal civil infraction violation notices. We got two things. Right? You broke an ordinance. They're either going to give you a municipal civil infraction citation or a municipal civil infraction violation notice. Why not just one? Well, the game is too easy to figure out when there's only one. There's two. Bureau means the City of Coldwater Municipal Ordinance Violation Bureau. So this municipal civil infraction violation notice is something that you have to go to the Coldwater Municipal Ordinance Violations Bureau to take care of. Right? You don't go to court. You go to court for a citation. You go to this other place if it's a infraction notice. Of course, you're never going to know because you're not ever going to see the paper. Municipal civil infraction citation means a written complaint or notice prepared by authorized city official directing, again, it says authorized city official. Can't be a private contractor. Directing a person to appear in court regarding the occurrence and existence of municipal civil infraction, blah, 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 blah. The violation notice means a written notice prepared by an authorized city official directing a person to appear at the City of Coldwater Municipal Ordinance Violations Bureau and pay a fine and cost. Right? Appear in court or appear at a bureau. Two different, the same act, two different offenses. So you're not being tried for the same offense is what they're going to say. Because the one that's under a citation, they're going to use some state code frickin' number. And on the other one, they're going to use, whatever the ordinance name is. Municipal civil infraction, directing to appear in court, and the other one to appear in municipal. Okay, yeah, got that. Municipal civil infraction shall be issued and served by authorized city officials as follows. Again, it's all about authorized city officials. So you would so if you get a ticket and you're in Coldwater, Michigan, you would go and send it to in my opinion, I'd send it to the city manager and say, hey, was this done properly? Because when you look at it, you're going to see that the guy didn't sign it in his name. He put his title down or something else, but he didn't put it in his name. The original shall be filed with the district court. This is the citation, right? Copies of the citation shall be retained by the city and issued to the alleged violator. So you're supposed to get your copy of the citation from the city. And if I'm not mistaken, when you get a ticket, information is coming from the court. Well, what happened to the one coming from the city? They're supposed to send you the one about the citation. You didn't get proper notice. All right, that's why I'd be telling the judge if it's already too late, I didn't get proper notice. But this is the thing. You're supposed to go back now to whoever the trier of the fact is and say, I was never given proper notice. I never got this piece of paper they're talking about. Citation for municipal civil infraction signed by an authorized city official shall be treated as if under oath. This is the citation. This is the real ticket deal, right? If the violation alleged in the citation occurred in the presence of the official signing the complaint, and if the citation contains the following statement immediately above the date and signature of the official. Your signature has nothing to do with that scribble that you put on the paper. Your signature is your full name written out. If it's in block letters like this here is, that's your signature. That shit you're doing with your pen, that's your autograph or that's your seal or whatever else you want it to be, but it's not your signature. Your signature is your full name. So Officer Peterson isn't somebody's signature. It's not their name, that's their office, their title. Signature is your full name. First, middle, last. I declare under the penalties of perjury that the statement above are true to the best of my information, knowledge, and belief. So what this is saying is, on that citation, wherever the dude's going to sign, I think it said immediately above, where the signature is, it needs to say, I declare under penalties of perjury that the statement above are true to the best of my information, knowledge, and belief. If it says anything else, then it's a simulated legal process. Because this city said that's what it's going to say. And it's going to have a signature. If that shit's missing, head on over to the authorized city official and find out what's going on. They're not going to want you to find the city manager. So I'd make a copy of it and mail it to them. An authorized city official who witnesses person commit an infraction shall prepare, subscribe as soon as possible, completely as possible. Yada yada yada. Okay. An authorized city official may issue a citation to a person based on investigation of a complaint by someone who allegedly witnessed the person commit a municipal civil infraction. Right? That's the paid informant, or it could be you. The official has reasonable cause to believe the person is responsible for the infraction. Right? Give them some kind of documentary evidence. And if the city attorney approves in writing the issuance of the citation. So, sounds like the city attorney is acting as the administrative judge. Or he's acting as law enforcement, one or the other. But what we want to do is we want to go to the authorized city official who, based on the investigation of a complaint that he's going to do, we're going to put the complaint in, he's going to investigate, he's going to take it to the city attorney. Shall be served by authorized city officials as follows. Except provided in paragraph 2, an authorized city official shall personally serve a copy of the citation upon the alleged violator. So if it's a citation, they're supposed to bring it to you, right? This is because you're going to court. And the proper thing to do is a court servicer show up at your house and give it to you. Not mail it, give it to you. A municipal civil infraction shall contain the name and address of the alleged violator. More. Okay. The municipal civil infraction alleged, the place where his alleged violator shall appear in court, the telephone number of the court, the time at or by which appearance shall be made. Further, the citation shall inform alleged violator that he or she may do one of the following: admit responsibility for the civil infraction by mail and personal representation at the time specified for the appearance, or admit responsibility for the municipal civil violation with explanation by mail, or deny responsibility for the municipal civil infraction by doing either of the following: appearing in person for an informal hearing before a judge or district court magistrate without the opportunity of being represented by an attorney unless a formal hearing before a judge is requested by the city. There's a lot to say. If you get a citation, you're supposed to be able to walk into the judge and say, well, I deny responsibility. They didn't sign the damn thing. But they're not giving us these citations, right? Or it may say citation, but they're not following the steps on it. It doesn't have the dude's signature, right? It's a simulated legal process to look like a citation. That the citation shall contain a notice in boldface that the failure of the alleged violator to appear within the time specified in the citation or at the time scheduled for the hearing or appearance in the misdemeanor will result in entry a default judgment against the alleged violator of the municipal violation infraction. Right? You're supposed to go between the time you get this and court and whatever the court date is. You're supposed to be able to go in and appear. You don't need to wait to the court date. Go in early. Now this is the other one. This is the Violations Bureau. So those were citations going to court. This is the Municipal Ordinance Violation Bureau. The Bureau shall be located in City Hall, shall be under the direction and control of the Finance Director. The Finance Director, subject to approval of the Council, shall adopt rules, regulations for the operation of the Bureau. So go there and ask him for the rules and regulations of his Municipal Ordinance Violation Bureau. The Bureau may dispose only of municipal civil infraction violations which a fine has been scheduled and for which a certain municipal civil infraction violation notice has been issued. Right? They don't do it for citations. They do it for notices. Nothing in this chapter shall prevent or restrict the city from issuing a municipal civil citation for any violation or from prosecuting any violation in a court of competent jurisdiction. Right. The fact that a fine has been scheduled for a particular violation shall not entitle such person to dispose of a violation at the Bureau. The fact that the fine has been scheduled for a particular violation shall not entitle any person to dispose of the violation at the Bureau. Well, you're going to explain that one to me. Well, because here's the thing, right? This says they have to have issued this notice. I think that means they have to have mailed it to you. The scope of the Bureau's authority may be limited to accepting admission of responsibility for civil infractions and collecting and retaining civil fines and costs as a result of those admissions. Appearance, payment of fines and costs. An alleged violator receiving a municipal civil infraction violation notice shall appear at the Bureau and pay the specified fine and cost at or by time specified for the appearance of the municipal civil infraction violation notice. An appearance may be made by mail and personal representation. Procedure where admission or responsibility is not made and fine not paid. Right? Like you didn't get this notice. A municipal civil infraction citation may be filed at the district court and a copy of the citation may be served by first class mail. Right? It's going to be because you missed your frickin' hearing. But shall consist of the citation filed with the court does not need to comply with all the particulars the way it should have before if they had just done that in the first place, but shall consist of a sworn complaint contained in the allegation stated in the municipal ordinance violation notice, shall fairly inform the alleged violator how to respond to the citation. Here's an example. In this town, disorderly conduct, if you just went and took care of the fines, a $25 fine. Right? Disorderly conduct is what they're trying to put Roe in jail for. Right? Because she can't find where to pay the $25. Violations of municipal law are prosecuted in the 3rd District Court. Right? 3rd. Written out 3rd. When you walk up to the door, though, it's going to be 3, the number 3 RD. Right? So this they keep handing this damn paperwork that they want us to fill out, and if you're going to fill it out, it's going to be the 3rd District Court, written out 3rd District Court. It would seem would be the proper thing to do, but I don't have to deal with that. I'm just showing that, you know, they got 2 different ways that they're handling this violation, and this is the same out in the county with the sheriff, because the county is considered a municipal corporation. Right? It's considered a municipal corporation. And so any area within the county that's not an organized municipality is going to be under their jurisdiction, and they're going to be doing the same thing. Right? And so there's some place in the county you can go to take care of these ordinance violations, and so we're going to look at some documents here that that could have applied to this kind of stuff. Like, okay, this is the complaint that they had against Roe, right? And on this complaint, they put her name backwards. They took her state ID and they put her name backwards. It isn't the way it shows up in her state ID, right? That's official misconduct. Disorderly conduct, they wrote it out, they put a number, right? There's your 2 different ones. It could be disorderly conduct as a municipal violation, or it could be a state infraction for a Class C misdemeanor. It's got a report number, but there's no peace officer involved. In fact, as you can see, they made sure down here in the bottom right hand corner, they X'd out peace officer. Right? No peace officer's been involved in this piece of paper yet. And this Kenneth J. Sison, who is doing this as a notary, right, has just committed a misconduct as a notary, because the way this is not in conformity with what the law says it has to be in the handbook. Someplace on here it has to say state of and county of. Right, for a notary to verify that you've done this and swore to this complaint, it has to be done by notary certificate, and certificates have a certain information they have to have, and that ain't on there. And that was one of the things that we complained about to talked about it in the last video, to the Inspector General for the Executive Office of the Executive's Inspector General, Chicago, and they had wrote Roe a letter, and now they've called her. She missed the phone call. We'll get it next week, but the guy they called said who he was and where he was from, and that he had jurisdiction in this matter, and for her to give him a call. Yeah, let me look at that right now if I remember where I put it. Where is that? Arrest warrant? Letter from Inspector General. Okay. This is the letter. Right, we sent a complaint to the Office of Executive Inspector General. Well, that's like, same as saying Internal Affairs. We'll be talking about them shortly at the police department, but Internal Affairs. And they gave her a complaint. It's got a complaint number, 14-01962. Well, that's a lot like this other complaint. 13-12345. It's a 5-digit number. What was this one? 1, 2, 3, 4, 5. 5-digit number, right? It's a complaint. It's the same as this, whatever Roe did, and I showed it in the last video, so it's not I don't know what she did, but I'm not going to go through it all again. Right? It's being treated as a complaint, like this police report complaint. Beautiful. And we were basically complaining about this court case and, official misconduct of this notary because of that. And more importantly, that this oath of office for this associated judge who's in supposedly hearing the case, right, that it hasn't been done in due form of law because there's no verification of the oath. This Judith M. Brokaw, who says she's a chief judge, fine, but you're doing a notary act and you have to follow the notary law, and so where's the seal? And where's your office? Because this chief judge, by her putting chief judge down here all by itself, and you look at whose paperwork this is, seal of the Supreme Court, she's saying she's the chief judge of the Supreme Court. So she didn't do Elizabeth K. Flood's oath properly. And also, Elizabeth K. Flood, right, she's called a declarant. Well, a declarant declares on a declaration, and that's an unsworn statement. I mean, that's what the definition of a declarant is. Right? She should be the office holder or something else, I would think, right? The other thing is, look at the date, February 7th, 2013. By the Supreme Court rules of Illinois, these associate judges of the circuit court are picked in an election and take office on the 1st of July of whatever year it is. And they hold office for 4 years. And after that, they need to be either reappointed or, kicked out and somebody else will be put in. But it's a 4-year rotation. They got to do this stuff every 4 years. And it isn't February 7th, it's July 1st. So we said that this was, that this is not an oath of office. And that, they're concealing something up here in the corner. Right, that's concealment. Plus, this has got a staple in it. There's a second page. Don't know what that was about, but, we pointed all these things out. And the same with this one. This one's for the judge that signed the other one. Right? That this one isn't done right either because it doesn't have the signature, the printed name of the person. And it calls himself a circuit judge. It doesn't give none of this stuff gives any of the jurisdictional things that need to be. State of, county of, so forth and so on. These aren't oaths of office. They're just pretty pieces of paper. But by law, it's not an oath of office. So, we put all that stuff together, and we sent a complaint on to the Inspector General, and the Inspector General sent back this letter. And then Roe was out. We were putting other paperwork into basically the internal affairs of the Sheriff's Department. She didn't realize she got back, and it was a little bit too late to call, but she had gotten a call from this office, from somebody who said he was from this office, gave his name, his phone number, and said he had jurisdiction in this matter for her to give him a call. That's really cool, man. That ain't never happened before. So let's look at one last thing on this. Maybe. Oh, yeah. Here is the arrest warrant, right? It's called an arrest warrant. It's not called a bench warrant. It's called an arrest warrant. And arrest warrants are used in admiralty. And as it said, with an arrest warrant, it needs to be from the clerk of the court. And it is. This doesn't have any court There's no court seals on it. It's from the clerk's office. And it comes from the clerk's office when it has to do with amity law. And they didn't do what it said. You're commanded to arrest the defendant designated herein and bring said person without unnecessary delay before the judge of the circuit court. None of that happened. And right, the thing was, here Judge Flood is called Flood Betsy. That's her signature, Flood Betsy. What the hell is that? Here's a little scribble, but that ain't who it is. But there's no return of service. There's no badge number, no police agency, no date, no service return, no mileage. There's nothing, right? This was never returned. So, and the people of the state of Illinois is a municipal corporation, comma, the plaintiff. All right, this is paperwork going into a court case. This isn't a bench warrant to start a case. This is an arrest warrant in an ongoing case. And where did they do that? Where's the other one at? Probate. All right. When Roe first went to jail for this little fiasco, this is the only piece of paper she got. Right, and you might believe it's a bail bond because it says bail bond on it, or you might believe it's called a certificate of defendant because it says that. But what it is, it's a piece of paper that hasn't been filed yet in the circuit court of the 16th Judicial Circuit, Kane County, Illinois. But as soon as you sign it, they're going to put it in the court case, and they even got they started a court case number. They know it'll be 13 CM, but they don't know what the rest of it will be yet. Right, so what they did is they had Roe sign this piece of paper. Right, they said there was a complaint against her, and they took her to some facility and made her sit there until she would sign this piece of paper, and then they released her. And what it said is, I, the undersigned defendant, do hereby acknowledge myself to be indebted to the people of Illinois or the city or village set forth as a municipal corporation. The people of Illinois is a municipal corporation in the sum indicated as bail. Bail was set at, doesn't have a dollar sign. I mean, I don't know, that's $1,200, but they're going to say it's $1,200. They're assuming you to believe it's $1,200. But if you understand, this is for disorderly conduct, and it's a Class C misdemeanor, and it has a $120 cash bail, and she gave him $120. That isn't what they did. They made it a $1,200 bond and said she's indebted to them. And then I have deposited the amount set forth herein, and I, the undersigned defendant, acknowledge the conditions of the bail that follow. Right? Well, they said that she's in for $1,200. Right? Forget the bond, that I have deposited the amount set forth herein. Well, how much was set forth? $1,200. It's what she's agreeing that she did. Well, she didn't give him $1,200. She only gave him $120. Right? So she broke her promise. That's the way the game's played, right? Boom, got what we needed. And when you look here, right, somebody who's claiming to be a peace officer, apparently, because they scratched the other two out, but you can't read who it is, signed before me and security received. Who? Signature of defendant. They didn't want her signature, right? None of this happened down here. Right? This apparently this all goes together down here. Assignment of bail by the defendant. Okay? So this isn't bail bond paperwork. This is a piece of paper that's going to go into the court case saying you just agreed that you owe them $1,200. Sneaky. Okay, so that's the police stuff. Now, will they do anything about it? Let's go back and look. All right. Here's just an example. This is Former Elgin Deputy Police Chief indicted on identity theft, official misconduct. Right? Facing identity theft and official misconduct charges. 16 counts of identity theft, that's a Class 3 felony, and 4 counts of official misconduct, that's a Class 3 felony. And what is this for? Well, he goes turned in for, breaking into somebody's email account. Four occasions between June 8th and 25th, accessed the law enforcement agency's data system to gain information on specific individual for his personal use. Used personal identification information of someone he knew to access that person's personal email account. Right? So basically, for the simple thing of getting into somebody's email account, forget putting somebody in jail and beating them up and all this other shit, shooting them. No, man, he's getting hammered for breaking into somebody's email account. And the reason is that whoever this was complained about it. They took it to internal affairs. Here's another guy. Just real quick, there had been a 2-car accident, and the guy that this is about, the victim, was involved in the accident. He got out to see what happened, and somebody who wasn't even involved in the ongoings reached down into his pant leg and pulled out a gun and told him to stand there, and da-da-da-da-da. Ended up that this guy was a county sheriff's department, county sheriff deputy. So I don't know what it was all about, but according to Qualzak, the man in the street clothes identified himself as a deputy and claimed that Qualzak had a weapon. Qualzak was then handcuffed and placed in a squad car. I was told, you're not being arrested, this is for your own safety. There you go, right? So they made sure to tell me he wasn't being arrested, because they're not really, again, I don't believe that they're actually peace officers. They can't arrest them. But Lieutenant Chris Collins of the Office of Professional Standards in Kane County Sheriff's Office said Kowalski's complaint was made Friday night following the incident, and his office began their investigation when they received the initial report on Monday. Well, there you go. So that's what we did, is we sent the complaint to the Office of Professional Standards. And I don't have the one on here, I wish I did, but there was another one that happened back in early 2000s where a sheriff's deputy pulled a lady over for a ticket and basically said, let me take pictures of you naked and I won't give you a ticket. She filed a complaint. They set up a sting. The guy showed up. He got busted. And it went on to say in the last line from the sheriff that if you have any complaints against any of his officers, that you're supposed to get a hold of the Office of Professional Standards, which is internal affairs. Right? Office of Professional Standards is responsible for gathering the written reports, interviewing anyone involved, and anyone who witnessed an incident, and then determining the outcome, which falls within a set of categories. Sustain, the allegations are against officers, prove true. Right? So very few things they can do. Sustain, not sustained, exonerated, unfounded, police failure. We're trying to get it sustained. So Collins said that his department is part of the broader Kane County Sheriff's Department. It is treated as a largely separate entity. So, we're going to see what they have to say. And we're going to point out that, in Roe's case, that there wasn't a peace officer involved. It's a simulated legal process. Judges don't have oaths. Right, here's our evidence. Well, while she was out putting that in, is when this guy called from the state Inspector General's office. It'll be an interesting Monday, to say the least. Alrighty. Do I have anything else to talk about on this? I don't believe so. We're gonna move on now to the attorneys. Everybody's favorite. this much to read. Holy shit. Let's look at the Attorney Act. This is the Attorney Act of Illinois. You may have one called the Attorney Act. Go look. No person shall be permitted to practice as an attorney or counselor at law within the state without having previously obtained a license for this purpose from the Supreme Court of this state. A license from the Supreme Court. And it looks something like this. Alright? If he ain't got one of these, he don't have a license in the Supreme Court. This is like from November 1987, right? So I don't even know they do this anymore. But this is what they look like. And down here, let me see. In testimony whereof, I can make it bigger and not lose my spot. Let's see what the clerk had to say. I, whoever, clerk of the Superior Court, Supreme Court, do hereby certify that our friend David here has been regularly licensed and admitted to practice as an attorney and counselor at law within the state, and has duly taken the oath to be, I can't read what it says. Oath to support, oath to support the Constitution of the United States, of this state, and also the of office prescribed by law, and that I have duly enrolled said name on the roll of attorneys and counselors, attorneys and counselors in my office. The clerk has the list of attorneys and counselors that have a license to practice law within the state. And an attorney is an office. And the office of attorney is an officer who's considered an officer of the court and always in court. So if you go to court and there's an attorney there, you need to know if this court has a copy of his license. Cool stuff. Okay, so you saw what one looked like. So no person shall receive any compensation directly or indirectly for any legal services other than regularly licensed attorney, nor may an unlicensed person advertise or hold himself out to provide legal services, which is why they always say, well, we can't give you legal advice, we can't give you legal advice, we can't give you legal advice, except for the guy who says he's an attorney. He'll give you legal advice, but guess what? He's not licensed regularly. He ain't an attorney. He's impersonating an officer, and he's in contempt of court. And it's back to the fleet. 30 days in the brig, back to the fleet, as Lord Coke would say. A license as provided for herein. And we saw what that looked like. Any person practicing, charging, receiving fees for legal services or advertising, holding himself out or herself out to be provide legal services within this state, either directly or indirectly, without being licensed to practice as herein required, is guilty of contempt of court, and shall be punished accordingly. Upon complaint being filed in any circuit court of this state, what do? You put a complaint into the frickin' circuit court of the state. Right? Put it in your court case. Hell, you're in a circuit court. If you're in Illinois, that's where they have you, in the circuit court for the 16th Judicial Circuit. Put a complaint in. And say you don't believe the attorney's licensed to practice law. The remedies available include, but are not limited to, appropriate equitable relief, civil penalty not to exceed $5,000, which shall be paid to the Illinois Equal Justice Foundation. Sorry, Bob in Arizona. I told Bob about this $5,000, forgetting that it had said the rest. I said, I think that's your bounty money. But it isn't. It's going to go to the Equal Justice Foundation. And actual damages. Such proceedings shall be conducted in courts of the respective counties where the alleged contempt has been committed. in the same manner as in cases of indirect contempt, and with the right of review by the parties thereto. You're supposed to go put a complaint into the circuit court, any circuit court of the state, which means the one you're walking into is good enough. I want to file a complaint, contempt of court. I don't believe this man has a license. Can this court produce his license? He's supposed to be an officer of the court, and I don't want you to presume. I want you to prove. Section 5 of the Corporation Practice Law prohibits representative of a party by a person who is not an attorney in proceeding before. Okay, basically, you need to be an attorney. No person shall be entitled to receive a license as for said unless he is a citizen of the United States. Show me the certificate. Or unless he has made a declaration of intention to become a citizen, or unless, having made such declaration of intention, he has filed a petition for naturalization within 30 days after becoming eligible to do so, and until he shall have obtained a certificate of his good moral character from the circuit court, which is another thing. They got to fill out this certificate of good moral character. Lots of little pieces of paper they have to have. Having a P number ain't good enough. You can get a P number and not be and be an inactive attorney. Every person admitted to practice as an attorney and counsel at law shall, shall, I love that word, before his name is entered upon the roll to be kept herein provided, take and subscribe an oath. I do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Illinois, and that I will faithfully discharge the duties of the office of attorney and counselor at law to the best of my abilities. That's a frickin' oath of a public officer. Busted. Right? They charged that frickin' police chief with 16 and 420 different felony charges for getting into somebody's email account. What do you think they'll do when you say, hey, this guy's trying to take, my house? This is a little more due than just my email account. It shall be the duty of the clerk of the Supreme Court to make and keep a record, stating at the head, therefore, thereof, that the persons whose names are herein written have been regularly licensed and admitted to practice as attorneys and counselors at law within the state, and they have duly taken an oath of office as prescribed by law, which shall be certified and endorsed on the license. And so Roe called the clerk's office at the Secretary of State, or at the court, Supreme Court, Illinois, and said she'd like to know where this role is for attorneys. And they said, well, you're going to have to call this other office, which is the one you would think of when you want to check to see if an attorney's an attorney or whatever. And she said, well, no, this says here that it's kept by the secretary or the clerk of the court. And they said, oh, you'll have to mail for that information. Right? Not going to give it to you over the phone. Need to mail them. Good to know. No person whose name is not on such roll, with the day and year when the same was written thereon, shall be suffered or admitted to practice as an attorney or counselor at law in any court within this state. Their name ain't on the roll. They're not an attorney. You ain't checked yet. It would be the next thing I'd be doing. And they make it easy. I'll show you another one where they're going to give you the place to go to. All attorneys and counselors at law, judges, clerks, sheriffs, and other officers of the several courts within the state shall be liable to be arrested and held to bail, and shall be subject to the same legal process, and may in all respects be prosecuted and proceeded against in the same courts and in the same manner as other persons are. Any law, usage, or custom to the contrary notwithstanding, I don't care if they believe they have sovereign immunity. It says I can take their ass to court. Why? Because they're impersonating an attorney. Because a judge, a clerk, I bet you all these offices you need to be an attorney. This sheriff here, this isn't the county sheriff. This is the king's main businessman. I'm going to say it's the, for lack of a better term, the city manager, the county administrator, somebody like that. No person shall be suffered to enter his name on the roll or record to be kept, as foresaid, by the clerk of the Supreme Court, or to do any official act appertaining to office of an attorney or counselor at law. As for no coroner, sheriff, deputy sheriff shall be permitted to practice as an attorney or counselor at law in the county of which he or she is commissioned or appointed, nor shall any clerk or deputy clerk of the court be permitted to practice as an attorney or counselor at law in any which such yada yada yada, until he or she has taken the oath as required. Right? So when these attorneys get out of law school, they go to a mass swearing in, and they stand up there and everybody raises their hand, they swear in, but nobody is subscribing the paperwork. I don't know that to be true. I'm just betting that to be true, and until it's proved different, I say it is. Right? So now if there's a controversy, well, we need to have somebody, we need a trier of the fact to go look at the facts and see if they're frickin' sign their damn oath or not. Plaintiffs shall have the liberty of this is big. Section 11. Plaintiffs shall have the liberty of prosecuting and defendants of defending in their proper persons, which is Robert Allen Rutlewski, not Rutlewski, comma, Robert A. or Robert Allen or any other bullshit. Robert Allen Rutlewski is the only way, Section 11, pointed out, say I'm not being sued in that name because that ain't the name on the docket. When you walk into court, you look at all those names they're going to hear that in cases today, they're all going to start surname, comma, given name. And so, when you get to be sued in your proper person, guess what? You now have a sui juris legal personality. Name changes of the Illinois Supreme Court's roll of attorneys and the ARDC master roll. That's the one they were talking about. They told Roe, you got to call the ARDC for the master roll. I said, I don't want that one. I want the roll that the attorney, that the Supreme Court has. The Supreme Court's roll of attorneys. The Illinois Supreme Court's roll of attorneys. That's the one you want. Is a list of all attorneys admitted to practice law in Illinois. The roll includes the names of lawyers even if they are not registered with the Attorney Registration and Disciplinary Commission, ARDC. It's a different one. The roll is maintained by the clerk of the Illinois Supreme Court. End of the controversy. A lawyer's name on the roll will reflect the name under which the lawyer was admitted to practice of law in Illinois, or any subsequent name change allowed by the court. And the reason I highlighted that, I will show you. When we go here, where's it at? Where are you at? William O'Grady? My favorite piece of paper ever. Right here. To show you how crazy the system is, right? This should be the Great Seal of the state of Michigan. Except the moose doesn't look back over his back like this critter on the right does. He would be looking towards the shield in the center, like the other critter is on the left. This is a counterfeit seal. And P. William O'Grady, when you go look at his name on the state bar site, is Patrick W. O'Grady. He's doing business in an assumed name. Right? It's not the name that he put down on the frickin' excuse me. It's not the name that he's admitted to practice law under. Right? And you need to be able to practice law as an attorney to be a judge. So, to me, it has to be the same name, or there has to be a name change in. And man, one more thing to find out. You need not serve the RDC with a copy of the motion, right? So if you want to change your name for whatever reason, you're supposed to send it to Carol Taft Gobswell, Clerk of the Supreme Court of Illinois. There's the address. If you want to know somebody in Illinois, contact them, because that clerk is supposed to be the keeper of the roll. And again, that roll is called, write it down, Illinois Supreme Court's Roll of Attorneys. And it's the roll maintained by the clerk of the Illinois Supreme Court. That's the one you want. And if it's not, you want a certificate that says that name isn't on our rolls. Okay, so cool. What did I do that for? Where am I at? Ooh, many things to look at. Supreme Court rules. Okay, so this is the Supreme Court rules for Illinois. Committee of Character and Fitness. Pursuant to the rules, procedures, the Board of Admissions and the Bar of the Committee on Character and Fitness shall determine whether each applicant presently possesses good moral character and genuine fitness, blah, 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 blah. Right? At all times prior to his or her admission to the bar of this state, applicant is under continuing duty to supplement and continue to report fully and completely to the board's admission, so forth and so on. The board shall transmit such certificate to the court together with any additional information or recommendation that the board deems appropriate. Character and fitness certification is valid for 9 months from the date of certification. An applicant who has been so certified and who has not been admitted to practice within 9 months must be recertified after finding the requisite character. This is where they get these guys, because they have them do this in their first year of college, of law school, to get this character and fitness certification done. Well, if they don't within 9 months go and take the bar exam, they have to redo it. And I don't think that's happening. So what they did is the Supreme Court had made up this committee on character and fitness. For each judicial district are hereby respectively constituted bodies of commissioners. And what do commissioners do? But they commission people of this court who are hereby empowered and charged to receive and entertain complaints, to make inquiries and investigations, to take proof for the time to time as may be necessary. In other words, if you have a complaint against an attorney within your judicial district, I think there's 5, that's how they did it here, and it's done different wherever it is, you need to go to the Committee of Character and Fitness, because they have the jurisdiction in this matter. And right, Committee on the Character and Fitness evaluates the moral character and general fitness of applicants to practice law, and it lists who they are. So I think where Roe is, it says Patrick A. Salvey, 2nd Judicial District. Right? It sounds to me like you write him and say, I don't believe that this guy is who he says he is, or whatever. We'll figure that part out. But here in a bit, I'll show you. I'll show you a complaint. All right. Here's what what I'm looking at. This is a United States District Court, and this is General Bar Admission for new Illinois attorneys. Please note that no swearing-in ceremony will be held. Instead, petitioners must have oath of office notarized. Oh, okay. Oath of office must be notarized. Well, they told me twice. They tell me again, oh, please sign the oath of office, excuse me, on the last page and have it notarized. Notarization replaces sworn in by a judge. No ceremony will be held. Only petitions bearing the petitioner's signature and completed on the form furnished by the court will be accepted for filing. Oath of office must be notarized. Well, they're telling these guys this going into this place, but right, other places they just have a swearing-in ceremony. So in Michigan, we have, ours is called the Attorney Grievance Commission. And this is the form you fill out. All right, please fill out the entire form in ink, sign at the bottom, provide a copy of any relevant information. In order to expedite the process in your complaint, please provide 2 copies of any supporting documents. Simple enough. All right. Name, address, city, type of case. You don't even need to be involved in the court. All right, just put the dude's name down and say, I don't believe this guy has got a license. All right, I request the Attorney Grievance Commission investigate the above matter. And the idea is these guys investigate, and then this other thing that people normally go to complain to, they adjudicate. All right, that's the judge, but you didn't go to the investigator first. Let's see what that is here. Just a second here. Let's see. State Bar, bits or pieces. Appear and present Board of Law Examiner certification sent by mail at a mass swearing-in ceremony or to one of the circuit courts of the state for a complete list of swearing-in ceremonies. Upon motion made in open court by a licensed Michigan lawyer, the court will administer the oath of office and enter an order admitting you to the bar of the state. So in Michigan, you actually have to have an order from the court that says you've been admitted to the bar. It's called the order of admission. Ask your attorney, you got an order of admission? Ask the judge, does this attorney have an order of admission? How do I find out this guy's got an order of admission? Who is this attorney of record in this foreclosure? Does he have an order of admission, Your Honor? Because, and I don't have it all here, but when you point something out to an attorney about another attorney breaking the law, he has a duty to do something about it. And you tell the judge, you an attorney, judge, you got an order of admission? Right? I'm porting out a felony to you. Right? Misprison a felony, you don't do something about it. I believe this attorney could be in contempt of court. What say you? If you're not the trier of the fact, let's go find the trier of the fact right now and let's get this decided. After the membership application order of admission dues payment are received, your bar license P number is assigned. Only then are active members eligible to practice law in Michigan. Eligible, not authorized. Did I put that on here? Is that the one I put this on? I don't remember. There we go. Eligible. Fit and proper to be chosen, qualified to be elected, capable of serving, legally qualified to serve, capable of being chosen as a candidate for office. Right? A candidate. You're eligible, but you haven't been authorized yet. Authorized, sometimes construed as equivalent to permitted or directed or similar mandatory language. Possessed of authority, that is, possessed of a legal and rightful power, the synonym of which is competency. Are they competent to be here? All persons who are licensed to practice law in Michigan must be members of the State Bar of Michigan. In order to become a member of the State Bar, you must first take steps to become admitted to the bar. If you've recently passed the bar exam, the Board of Law Examiners has mailed you a certificate of qualification. A current active member of the State Bar must file this certificate and motion seeking your admission to the State Bar in the Supreme Court or a circuit court. You must also appear personally in open court to be administered the oath of office. Right, so you need to give this piece of paper to a current and active member of the State Bar, and he needs to file it by motion for you to be admitted. And then you need to go in and take an oath. Not you, an attorney. After being sworn into one of the circuit courts of the state or the Supreme Court of Michigan, you will need to complete a membership application to join the State Bar and pay your membership dues. To complete the State Bar Michigan new member application online, pay your membership dues, visit, do not create an account online until you've been sworn in. As soon as the State Bar of Michigan has issued you a P number, you will be a member in good standing and eligible to practice law, but you ain't authorized yet. Because an applicant is required to subscribe such oath of office by signing a copy of the registered membership, by signing a copy, and to register membership in the State Bar of Michigan in the manner prescribed in Rule 2 of these rules and pay the required dues before practicing law in the state. The clerk shall record such admission in a journal of such court and shall preserve such oath of office in the records of the court. A roll of all persons admitted to the bar shall be kept in the office of the clerk of the Supreme Court. So they're doing the same thing here. A roll of the persons admitted to the bar shall be kept in the office of the clerk of the Supreme Court. And you're going to talk to them. They say, well, you need to get a hold of the bar. Say, no, I need to get a hold of you because you're supposed to have a copy. Right? And if you don't know what I'm talking about, then get me your boss, because you're not going to be talking to the clerk anyways. You're going to be talking to, a countertrol. None other than a member's correct name shall be entered upon official register of attorneys of this state. Each member, upon admission to the State Bar and an annual dues statement, must provide the State Bar with the member's correct name and address and additional information as may be required. Right? We want to know how they put their name on that membership paperwork, because they use initials, or they make their first name an initial, or whatever they do. But if their name has their middle name or whatever it is on the membership paperwork, that's the only way they can do business in the state. If they're not doing business under that name, then they're not a licensed attorney. No member shall practice law in this state until such information has been provided. The name and address on file with the Secretary or with the State Bar at the time shall control in any matter arising under these rules involving the sufficiency of notice to a member or the propriety of the name used by a member in the practice of law or in a judicial election or in the election of any other public office. Propriety of name means, you got to use the right frickin' name. Every active member shall annually provide a certification as to whether the members or the members of law firm have a policy to maintain interest-bearing trust accounts for deposits of clients in third-party funds. Well, jeepers, I wonder who the third party is. That would be you. These are the guys that are playing the stakeholder. They're holding the stake. Whose property is it? And they have it in their account, and they're going to live off the interest instead of it coming back to you. Certification shall be placed in the face of the annual dues notice and shall require the member's signature or electronic signature. Right, so there's a lot of shit going on there, excuse my French, but the easy thing to do or to remember is the Attorney Grievance Commission. All right, we're looking for the for the guys that investigate. The guys that investigate. Admission to the bar, right? They take a little bit longer oath here in Michigan. I, blah, blah, I, a lot of I's. A roll of all persons admitted to the bar shall be kept in the office of the clerk of the Supreme Court. Right? So you can tell them per Rule 15 of the State Bar Rules of Michigan, admission to the bar, clerk, you got a name, I'd like to have a copy. I wonder if we could just get a copy, get the whole damn thing. That would be interesting. equals the state bar. Yeah, that's where that came from. I'm looking at this one last little thing, and whew, man, we could be done. Oh, unauthorized practice of law complaint. All right, non-lawyer's name. If the name isn't the same as it is, like you find it on the Bar Association site, well then, you know, P. William O'Grady is Patrick W. O'Grady on the state bar site. All right, so put P. William O'Grady here with his address, telephone number. Describe your complaint. You know, send it to them. See what they do with it. I wanted to point out one other thing. If you put a complaint in against a sworn officer, like a peace officer, it says on these forms they have that if, you know, per whatever state law, you need to, you know, swear to your complaint if you're complaining about a sworn peace officer. I know a lot of people have a problem swearing to things, so you don't need to because you're complaining they're not a sworn peace officer. Let's determine they're a sworn peace officer first, and then if I have a complaint, we'll go from there. But the first thing I need to do is have the facts adjudicated. Is he a peace officer or not? If he isn't, I don't need to go any farther. One last thing. Well, maybe a couple more. Looking at all this stuff, I've looked at a lot of different complaint forms, so I'd like to point them out when I see them. In the state of Michigan, under the Civil Service Commission, I think it is, they have a Board of Ethics, and it says, below are the standards of prohibited conduct in the State Ethics Act. Please check each standard that you allege was violated by the employee or public officer. Number 2, a public officer or employee shall not represent his or her personal opinion as that of the agency. Excellent. Right? I don't want your opinion. I don't want to know what your custom is. I don't care how you normally do it. This is how the law says. Show me something else, or it's an ethics violation against them. I don't want your opinion. I want to do what the law says. And they like to follow, you know, I mean, I don't blame them. They're just used to doing things the way they are, and they've been trained this is how you do it. And they don't know what the law says, but if you can show them, well, this is what it says, and they say, but that's not how we do it, say, I don't want your opinion, right? That would be an ethics violation. Do I need to file an ethics violation? If I need to, I will. But here you go, right? It's a complaint form. The State of Michigan Board of Ethics. That's all I need to point out. They share their opinion. They're not following the law. That was pretty much everything, I think. Golly, we got through it all. Ay, ay, ay. Oh, here's the affidavit I was talking about. So, in compliance with some section of the Illinois Uniform Peace Officers Disciplinary Act, I, whoever, the undersigned, being duly sworn on oath, depose and state as follows. And you go ahead and put it in there, right? But you need to do this because apparently the other guy is supposed to be a sworn peace officer. And we're going to say, well, first of all, prove to me as a sworn peace officer, right? Or he's breaking the law. And you're breaking the law if you don't do something about it, because I just pointed out to you, he's not a sworn peace officer. That gets him moving, I think. Who governs the practice of law? The practice law in Illinois is governed by the Illinois Supreme Court. Nobody else involved. The Illinois Supreme Court exercises its authority through the clerk of the court, Attorney Registration Disciplinary Commission, Board of Admission to the Bar, Committee on Character and Fitness, Administration of Office, and the courts. So this Attorney Registration and Disciplinary Commission, where they try to get you to go, is only one of the 5 things that needs to be done that constitute the complete authority of governing the practice of law. I'm sure we went through this one. Yeah, we did. Oh, maybe we didn't. So character and fitness. When the Illinois gained statehood, an admittee was required to obtain a certificate from the court of some county of his good moral character. And that has since been replaced by Supreme Court Rule 708, which established a Committee on Character and Fitness. And the Character and Fitness, they got their own registration program, and pursuant to 706, every applicant of Illinois' bar examination must file a character fitness registration application and a separate application to take the examination, bar examination. The character fitness registration must be filed with the Board of Admissions to the bar on or before March 1st of your first year of law school, right? Well, that's a long time from whenever they're going to take the test, and the certificate they get has like a 9-month shelf life. 706 for the states, character and fitness registration application is filed on or before applicant deadline, must be accompanied by a non-refundable fee of $100. Yeah, okay. The recommendations of the Committee on Character Fitness are forwarded to the Board of Admissions. Yada, yada, yada. So, application to take the board. I don't know that I want to read any more of this stuff. History of the board examination. It's just easy enough to go say, hey, I don't believe this guy's. Are you licensed? Can I see your license to practice law within the state? Put the question to him. Put the question to the court. Any person whose name is not on the master roll and who practices law or who holds himself out as being authorized to practice law in this state is engaged in the unauthorized practice of law and may be held in contempt of court. By God, they shall be. Right? And the master roll that we're speaking of is the one that's kept by the clerk. At all times, a copy of the master roll shall be on file in the office of the clerk of the court. Now, this isn't saying the Supreme Court, and so this could be at your local circuit court. I would go down and ask the clerk of the court to see the master roll of all attorneys authorized to practice in the court. Because they're supposed to be an officer of the court. So, does that mean officer of the 16th Judicial Circuit Court? Office of the Supreme Court? Office of the County Court? Right? Which one are they officer of? Well, whatever one you're walking in, say, I want to know if this attorney is an officer of this court. The one that you're in today, because that's at all times a copy of the master roll shall be on file in the office of the clerk of the court. An attorney who is not listed on the master roll is not entitled to practice law or to hold himself or herself out as authorized to practice law in this state. You don't need to go any further. And they also have to disclose trust accounts to hold property of clients in third persons in lawyers' possession in connection with their representation. Remember, I've read that before, but that was Michigan. This is Illinois. Apparently, it's done in more than one place. Subject to the supervision of the commission, the administrator. So who is this administrator? Do we know who it is? Because he's the guy you take your complaint to. I believe that we're talking about the administrator at the Rule 752. I have to go read it again. On his own motion or recommendation by an inquiry board or at the assistance of an aggrieved party, investigate conduct of attorneys licensed in Illinois and attorneys admitted in other United States jurisdictions who provide legal services on temporary basis in Illinois pursuant to whatever, and those conduct yada yada yada. So he's the guy that's going to do the investigation on his own motion, on a recommendation of an inquiry board, or at the insistence of an aggrieved party. Rule 752, Supreme Court, Illinois Supreme Court rules. If you Google that, it'll take you, you'll be able to get to the site. go down to 752 and go up a couple, and we'll know who we're talking about, because I forget who this was. I don't remember who they were talking about. I'm going to say it was the review board they have. I ain't gonna worry about it. Okay, anyways, please, if you can, please donate. PayPal, Ashley Rytlewski, gmail.com. Snail mail, Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. And don't believe that they are who they say they are. Make them prove who they say they are. And if you get a ticket, figure out in your whatever jurisdiction gave it to you. If it came from the state cops, it's going to be something to do in the city. If it came from the city cops, it's going to be something to do in the city. State cops would be something to do with like the Department of Transportation or something like that. And out in the country, it's going to be the sheriff. And all those are going to have some kind of review. In a small town, it's going to be like the city administrator. For the county, they're going to have some kind of internal affairs. That's the kind of things we're looking for to take it to. And I'm going to leave it up to everybody else to figure out their own, but that's a good place to start. And we get a little bit better idea, then we can maybe fill in some blanks. But until then, remember that, and remember that the name on your stub to your Social Security card that says it's the owner of the account is not your name. You're going to find a mistake. Space between the letters, have it in all caps, have an initial, whatever. Right? Not you. Excellent. You all have a great day. We'll see you. Take care.